to the extent that a federal bankruptcy judge was asked to stop Acosta from going forward before marketing specialists' chances of reorganization were totally destroyed. And that's an allegation of a wrongful act. And whether or not the trial judge, the bankruptcy judge, said it was wrongful or not, whether that was even an issue, doesn't matter, because it was an allegation of a wrongful act at a time before our policies were issued. And perhaps it would help if I backed up a bit and explained that our policies, our clients' policies, defend these companies or provide coverage for liability for wrongful acts, which is defined in the term, that arise in the policy period, where the insured has notice within the policy period. Because it's a claims-made policy, if the insured had notice of those wrongful acts at a time before the policy issue, there's no coverage. It's excluded. So what we look for here, the analysis is where the wrongful acts that were alleged in the Fourth Amended complaint, the same wrongful acts or related wrongful acts defined in the policy that were alleged in the turnover complaint.
It may not matter, but if your policy is in effect at the time of bankruptcy, would you have had coverage?
I would think we would, but they were not. There was a buyback period. The policies, I think, were sold and issued in 2002, but there was something called a continuity date. So a prior date of coverage was established back to November 1, 2001.
The turnover suit thing would not have been considered prior litigation.
If it had occurred after the continuity date, that's correct.
Do you agree that suit analysis requires the conclusion that repetition of a single fact from the turnover suit results in lack of coverage for the entire underlying suit?
The suit-to-suit analysis, I'm not sure about the answer to the question. I think that I would, Your Honor, the way I would approach it is the analysis is dictated by the terms of the policy, which require that we look to see if there's any prior or pending litigation or proceeding alleged the same or related wrongful act that is currently alleged in the action for which the insured seeks coverage. So you compare the two complaints.
If I'm trying to figure out how to frame this question.
I understand the complexity, Your Honor.
If we buy off that there was no wrongful act in the turnover to the bankruptcy, where would that put us?
We are in the same place, because it doesn't matter what the final adjudication was, if there was one, because it's what was alleged. Was there a wrongful act alleged? The liability policy insurance that we all have through our homeowners and our auto policies doesn't provide coverage if we're alleged to be if we're adjudicated to be not guilty. If we get sued, something is alleged against us, our liability coverage kicks in. And it doesn't matter what the final adjudication is. We have coverage for an allegation of negligence against us. Same here. Coverage exists for an allegation. I think that's the correct way to approach the adjudication issue. And that also touches on the question you asked. Can we look outside the record, or outside the complaints? And the answer is no, because the insurance policies insure against liability. Liability is alleged in a complaint or in a proceeding. Liability does not arise out of what somebody says in a deposition. Liability does not arise out of a letter that somebody wrote. Well, liability is a claim. And that's why we stick to an analysis of the wrongful acts that are alleged in the complaint for turnover, in the complaint that came later in the district court.
Well, counsel, for purposes of summary judgment in this case, if the exclusion clause was unambiguous for purposes of granting a motion to summary judgment, why did the insurers not figure out that it applied to 4 years after a customer joined the underlying suit?
I can't answer why it was not alleged. I can say, Judge, that there is no coverage by estoppel. There is no waiver. You can't waive, an insurance company does not waive itself into coverage by failing to assert a defense at a specific time. I don't know what the factual background of the investigation was or what the allegations of what we knew when, but it was asserted in sufficient time for the insured to do the discovery they needed to do and make the pleadings. I'm sorry, I cannot answer that question any more directly than that, but I know it does not make a difference to the outcome here.
One quick question. Assuming that the complaint in the underlying action in this case, had a number of counts and causes of action therein, if 25 of those, or however many there were, had no relation to the factual scenario in the turnover suit.
Yes.
And your opponents suffered a loss on those other claims.
Yes.
Although all of these things were in one lawsuit, would they then be entitled to coverage on those other claims or loss on those claims that had nothing to do with the factual scenario in the turnover suit?
I would say no. There is no duty to indemnify non-covered allegations. So if there was damages, whether or not there would have been a duty to pay for the defense of those allegations is another question. But there would be no duty to indemnify any damages, judgments entered against the insured for those non-covered counts.
Even though they didn't arise out of facts or a factual scenario that was the subject of a prior lawsuit?
If they were covered, if they were like first arose for the first time, yes, there would be a responsibility to. But I hear you describing covered claims.
Well, and what I'm describing, perhaps not as clearly as I could, is a situation in which you have one cause of action that would arguably not be covered or would be excluded, and then others that are unrelated to any other factual scenario that had come up in a claim before. I guess your opponents are suggesting that the sort of look at the complaint and it's all or nothing is the position that you're taking, and they're suggesting that that is unfair or unreasonable.
The position we're taking comes from the policy language arising out of. If the claims that were made in the turnover suit arose out of a nucleus of facts that are the same nucleus of facts out of which the Fourth Amendment complaint arose out of, and that's the position I'm taking. I see I'm in.
You're talking for a minute. I'm going to give your other counsel on that. But as I understand it, if there wasn't, I understand it was more still a response. If there were counts in that new complaint that did not arise out of the turnover suit, and they were covered in the contract, you would have to do
If they arose for the first time during the claims period, say it was totally unrelated directors and officers claim, if there would be a duty, it would trigger the coverage of the policy. If they rose for the first time in the policy period, but the point is, as a matter of law, it did not. Of course, that's our position. Thank you, Your Honor.
Okay. Clerk, would you have a minute and a half, and then add